The morning sun streamed through the towering windows of the Metropolitan County Courthouse, casting long shadows across the polished marble floors. The corridors buzzed with activity as lawyers hurried past with briefcases and tablets, their footsteps echoing off the vaulted ceilings. It was 9 a.m., and courtroom 412 was already filled to capacity. Judge William Harris sat at his elevated bench, his silver hair and wire-rimmed glasses lending him an air of authority that matched his reputation. In his 15 years on the bench, he had become known throughout the legal community for his stringent approach to justice, particularly when it came to young defendants. His colleagues often whispered that he seemed to take personal offense at any sign of youthful indiscretion. Viewing it as an affront to the dignity of his courtroom, the bailiff's voice rang out clearly. Case number 225-CR-1542, State v. Chen. The double doors at the back of the courtroom swung open, and a young man entered. He was 18 years old, dressed in a charcoal suit that seemed a size too large, his black hair neatly combed. Despite his youth, he walked with remarkable composure, his shoulders straight and his steps measured. Throughout the wood-paneled courtroom, the usual morning routine continued. Court reporters typed quietly at their stations, clerks shuffled through stacks of files, and attorneys engaged in hushed conversations with their clients. Yet, there was an undercurrent of tension in the air, as there always was when Judge Harris presided over cases involving young defendants. Judge Harris glanced up from his papers, his eyes narrowing as he observed the young Asian-American defendant approaching the podium. His lip curled slightly, and he adjusted his glasses with a familiar gesture that his regular court attendees recognized as a sign of dismissal. "Another one of these," his expression seemed to say, as he shuffled the papers before him with unnecessary force. The young man stood perfectly still, waiting to be addressed, seemingly unaware of the judge's disdain, or perhaps choosing not to acknowledge it. "Mr. Chen," Judge Harris drawled, peering down from his bench with barely concealed contempt, "I see you've chosen to represent yourself in this, rather, complex matter." He emphasized the word complex as if speaking to a child, drawing a few uncomfortable shifts from the attorneys present. The case before them involved a sophisticated financial dispute between 3 tech startups, where Chen was accused of unauthorized access to proprietary trading algorithms. The prosecution claimed damages exceeding $2 million, with evidence spanning thousands of pages of technical documentation and financial records. "Perhaps," Judge Harris continued, tapping his fingers on the bench, "you might want to reconsider your decision. This isn't like explaining social media to your grandmother or playing video games. We're dealing with serious financial laws here." A few nervous chuckles emerged from the gallery, quickly silenced by the tension in the air. The court clerk winced slightly at the judge's tone, and the prosecutor, Sarah Martinez, shifted uncomfortably in her chair. Even she, despite being the opposing counsel, seemed embarrassed by the judge's behavior. The court reporter's fingers hesitated briefly over her keyboard, and several veteran lawyers exchanged knowing glances. Michael Chen stood at the podium, his posture relaxed but professional. "Thank you for your concern, Your Honor," he replied, his voice clear and steady. "I've thoroughly reviewed the case materials and am prepared to proceed." He opened his leather briefcase, removing several neatly organized folders with color-coded tabs. "If it pleases the court, I'd like to address the prosecution's motion to compel discovery, specifically regarding the blockchain transactions dated March 15th through April 2nd. The slight tremor in Judge Harris's left eyebrow betrayed his surprise at the young man's articulate response. Yet he pressed on. "Well then, Mr. Chen, enlighten us with your unique perspective on corporate law. I'm sure we could all benefit from such youthful insight." His sarcasm hung heavy in the air, but Chen remained unruffled, methodically arranging his documents as if he hadn't noticed the mockery at all. "Your Honor," Chen began, "I'd like to cite the precedent established in Datatech Solutions v. Morrison, where the Ninth Circuit ruled that proprietary algorithms, when implemented on public blockchain networks, cannot be protected under traditional trade secret doctrine without clear access restrictions." He pulled out a highlighted copy of the case law, his fingers moving with practiced efficiency. Judge Harris's smirk began to fade as Chen continued, outlining a detailed argument about distributed ledger technology and its implications for intellectual property law. The young man referenced 3 more recent cases, each perfectly relevant to the matter at hand. Furthermore, Chen added, the prosecution's reliance on the Computer Fraud and Abuse Act is fundamentally flawed here. As established in Van Buren v. United States, merely exceeding authorized access doesn't constitute a violation unless there's clear evidence of breaking technological barriers. Around the courtroom, heads began to turn. The prosecutor, who had been casually reviewing her notes, now sat up straight, frantically flipping through her files. 2 veteran attorneys in the gallery leaned forward, their expressions shifting from mild amusement to genuine interest. Judge Harris's face had grown increasingly red. He attempted to interrupt with a procedural question about standing, but Chen smoothly responded by citing a recent state Supreme Court decision that directly addressed the issue. The judge's fingers, which had been drumming impatiently on his desk, grew still. The whispers in the courtroom grew. A senior partner from a prestigious law firm, who had stopped by for a different case, slipped into an empty seat instead of leaving. The court clerk had stopped pretending to do other work, her eyes fixed on the scene unfolding before her. And if we examine the blockchain timestamps, Chen continued, pulling up a technical analysis on his tablet, it's clear that the access nodes were, in fact, part of the public testnet, not the private production environment as claimed in the prosecution's brief. His explanation was clear, precise, and devastating to the prosecution's case. The atmosphere in courtroom 412 had transformed completely. What had started as another routine hearing had become something else entirely, and everyone present could feel it. Even the bailiff, who had seen everything in his 20 years of service, was watching with undisguised fascination as this seemingly ordinary teenager dismantled complex legal arguments with the skill of a seasoned litigator. Judge Harris, his face now flushed with a mix of frustration and confusion, finally interrupted. Mr. Chen, where exactly did you acquire this legal knowledge? A slight smile crossed Chen's face as he reached into his briefcase. Your Honor, I apologize for not introducing myself properly earlier. I'm Michael Chen, licensed to practice law in this state since last year. I passed the bar exam at 17, graduating summa cum laude from Yale Law School through their accelerated program. The courtroom fell silent. You could have heard a pin drop. I currently serve as a junior partner at Morrison & Jang, specializing in cryptocurrency and blockchain law. Last month, I was lead counsel in the landmark case before the Second Circuit that established new precedents for smart contract enforcement. Chen's voice remained modest but confident. I chose to represent myself today because, well, this is my area of expertise. The prosecutor dropped her pen, letting it clatter on the table. The gallery erupted in hushed murmurs. The court reporter's fingers froze over her keyboard as she stared open-mouthed at the young attorney. Judge Harris sat completely still, his hands gripping the edge of his bench. His face cycled through a series of emotions: disbelief, embarrassment, shock, and finally, a dawning recognition. The name clicked in his mind. He had read about this prodigy in the law review just last week, but hadn't made the connection to the young man standing before him. I see, Judge Harris managed to say, his voice having lost all its previous condescension. His mind raced back through every dismissive comment he'd made, every subtle jab, every patronizing gesture. Each memory now felt like a weight pressing down on his shoulders. The young man he'd been mocking wasn't just prepared. He was arguably the most qualified person in the room to handle this case. Several of the older attorneys in the gallery were now frantically Googling on their phones, their eyes widening as they found articles about the young legal prodigy who had been making waves in tech law. The whispers grew louder as they shared their discoveries. Youngest bar admission in state history. Published in Harvard Law Review at 16. Argued before the Supreme Court last month. Chen stood quietly, maintaining his professional demeanor, neither gloating nor showing any sign of satisfaction at the judge's discomfort. He simply waited, ready to continue with the case at hand, exemplifying the very dignity that Judge Harris had assumed he lacked. Judge Harris cleared his throat, adjusting his glasses with trembling fingers. Mr. Chen, he paused, visibly struggling with his words. I owe you an apology. My behavior this morning has been unbecoming of this court. Please proceed with your motion. Around the courtroom, people were still processing what had just happened. The prosecutor quietly closed her laptop, already knowing where this case was heading. A few veteran lawyers in the gallery had pulled out their business cards, clearly hoping to network with the young prodigy after the hearing. The court clerk was texting furiously under her desk, no doubt spreading the word to her colleagues in other courtrooms. Chen simply nodded at the judge's apology. Thank you, Your Honor. Returning to the matter at hand, he smoothly transitioned back to the case, presenting a detailed analysis of the blockchain transactions that completely undermined the prosecution's claims. His professionalism in not dwelling on the judge's embarrassment only seemed to heighten the impact of the earlier revelation. By lunchtime, the story had spread through the courthouse like wildfire. Junior clerks whispered about it in the cafeteria. Court reporters shared details in the break room. Even the security guards at the entrance were talking about the young lawyer who had humbled Judge Harris. Did you hear what happened in 412? Became the day's catchphrase. Each retelling grew more dramatic. How the teenage attorney had cited precedents from memory. How Judge Harris's face had turned 3 shades of red. How the gallery had gasped when Chen revealed his credentials. Back in the courtroom, the case concluded with a clear victory for Chen. The prosecution's motion was denied, and hints of a favorable settlement were already being discussed. But the real story wasn't about the case anymore. It was about how a young man's dignity in the face of prejudice had taught everyone present a valuable lesson about making assumptions. By the end of the day, as Chen packed up his briefcase, several senior attorneys approached him with congratulations and business cards. The same courthouse staff who had earlier smirked at his youth now held the doors for him with respect. And somewhere in his chambers, Judge Harris was quietly rethinking his entire approach to young defendants. As the day drew to a close, Judge Harris did something unprecedented in his 15 years on the bench. He asked his clerk to recall Chen to his chambers. In the private setting of his office, surrounded by leather-bound law books and the fading afternoon light, the judge offered a heartfelt apology. Mr. Chen, your presence in my courtroom today has forced me to confront some uncomfortable truths about my own biases, he admitted, his usual stern demeanor replaced by genuine remorse. I've realized that I've been viewing youth through a lens of prejudice rather than potential. In the weeks that followed, regular courthouse visitors noticed a marked change in Judge Harris's demeanor. Young defendants in his courtroom were now met with patience and consideration, rather than immediate skepticism. He began asking about their education, their aspirations, their circumstances, treating each case with individualized attention, rather than blanket assumptions. The impact rippled through the entire courthouse. Other judges, having heard about the Chen incident, began examining their own biases. The courthouse staff started a diversity and inclusion training program, with a special focus on age discrimination. Even the veteran attorneys seemed more willing to mentor younger colleagues. Chen's reputation soared within the legal community. His handling of the situation, maintaining professionalism in the face of prejudice, became a case study in legal ethics courses. Young law students cited him as an inspiration, and established firms actively sought his expertise in technology law cases. He began receiving invitations to speak at legal conferences about both tech law and breaking age barriers in the profession. 6 months later, at a State Bar Association meeting, Judge Harris and Chen found themselves sharing a panel on modernizing the justice system. The judge opened his remarks with the story of their first encounter, using it as a powerful reminder that justice should be blind not only to race and gender, but also to age. The day Mr. Chen walked into my courtroom, Judge Harris concluded, I was reminded that wisdom doesn't always come with gray hair, and respect shouldn't have to be earned twice because of how someone looks. In a system dedicated to justice, our own prejudices can be the biggest obstacle to fair treatment. Chen went on to establish a mentorship program for young lawyers, while Judge Harris became known as one of the most fair-minded judges on the bench. Their story became a reminder that sometimes the most powerful lessons in justice come from acknowledging our own injustices. The incident had transformed from a moment of humiliation into a catalyst for change, proving that even in a system as traditional as law, there's always room for growth, learning, and the breaking down of age-old assumptions.